Ready? 3, 2, 1 and go. During argument, Mr. Debashish Roy, learned advocate appearing for the petitioner, has contended that if there is an arbitration clause to solve the dispute between the parties as per agreement, the prayer under Section 8 of the 1996 Act could even be instituted at the stage of appeal, and he has relied on the decision of P. Anant Gajapati Raju and others versus PVG Raju died and others reported in AIR 2000 Supreme Court 1886. He has also contended that as per decision of ABP Private Limited versus Media Research Users Council reported in 2013 (1) CLJ 1-to-1 parties are bound and covered by the arbitration agreement only to solve the dispute in between them, and so the application under Section 8 should have been allowed. In the instant case, it is not the situation that the arbitration clause was not known to the petitioner, but from the conduct of the petitioner, it appears that he wanted to apply such provision only when the complaint case was likely to be disposed of shortly by the district forum. Therefore, in my view, the facts stated in the present case is quite distinguishable from the decision referred to by Mr. Roy, and as such, I am of the view that those decisions are not applicable in the instant case, since an arbitrator has already been appointed under Section 11 of the 1996 Act. Further, reference is not at all required. It is not unknown at what stage the arbitration proceeding is lying, but from the conduct of the petitioner, it is evident that he has wanted to stop the proceeding before the district forum upon overall assessment of the materials placed by the respective parties in the proceeding before the district forum. So, intention of the petitioner is very much clear from his conduct. The Consumer Protection Act 1896 is a complete code to entertain a complaint, and it shall be dealt with in accordance with the provisions of the said Act. If any party has any grievance against the order, judgment of any particular forum or commission, the said Act lays down how the grievance of an aggrieved party is to be dealt with. In such circumstances, the exercise of jurisdiction under Article 227 of the Constitution shall be rarely exercised only in the case where the action of the forum or the state commission is without any jurisdiction. In the instant case, the impugned order cannot be described as to have been passed without any jurisdiction by the Honorable State Commission. Under the circumstances, in my view, there is no scope to entertain the present application at all, and for that reason also this application is liable to be dismissed, since the reliefs under the provisions of the Consumer Protection Act 1986 are in addition to and not in derogation of the provisions of any other law for the time being in force. I am of the view that the State Commission has rightly rejected the prayer for admission of the revision, stating the reasons for rejection. Accordingly, in my view, there is no scope of interference with the impugned order. The application is devoid of merits and is therefore dismissed. Considering the circumstances, there will be no order as to costs. Urgent Xerox certified copy of this order is applied for be supplied to the learned advocates for the parties on their usual undertaking. And over.